Hi, this is Ross Jurewitz, here today to talk to you about common lawyer terms, common lawyer language, and what do they mean for your personal injury case. Burden of proof is the burden that an injured person, a plaintiff, has in proving their case. As the injured person, you have the burden of proving every aspect of your negligence case. Now, what does that mean? Well, that means you have to prove that every element of your case is more likely than not true. That's a different standard than what most people hear in terms of burden of proof. Often we hear burden of proof in terms of criminal cases, where we have to prove that someone has committed a crime beyond a reasonable doubt. That is not the burden of proof. That's not the standard in civil cases. The burden of proof, the standard of proof, if you will, in a civil case is simply more likely than not. That can mean, and we've used this term before in trial, that it is 51% likely to have happened, at least 51% likely to happen. It is something more than just a 50-50 chance. If you meet that standard, you have met your burden of proof in a civil litigation case. You have proven your case to a jury. We'll have more videos about commonly confused lawyer and legal terms later on. If you have other questions about other terms, feel free to submit them to us at jurewitz.com, and we'll be sure to include them in other future videos.